Good afternoon and welcome to the Court of Appeals. Your panel today is to my right, Judge Toby Hampson. To my left, Judge Julie Flood. My name is John Tyson. Our courtroom clerk is Mr. Eddie Saunders, and our court marshal is Officer Tom Ballou. Welcome, everyone. We have one case on the docket for argument this afternoon. Are there any preliminary matters to come before the court? Okay, hearing none, we will hear from the appellant. The case of State versus Martinez.
May it please the court. My name is John Carella, Assistant Appellate Defender, and I represent the appellant, Ms. Daisy Martinez. To my right at counsel table is Appellate Defender Glenn Gurdon, and I would like to reserve 5 minutes for rebuttal. At the age of 27, Daisy Martinez was sentenced to spend the rest of her life in prison for the death of Martin Garcia. The state and defense agreed that Martin was stabbed in the 8 minutes between 3:24 a.m. when he and Daisy exited an Uber in which they had been arguing and kicking each other, and 3:32 a.m. when Daisy called 911. But the issues raised in this appeal, the critical question for the jury, was whether the state presented sufficient evidence that Daisy acted with premeditation and deliberation in stabbing Martin. No one saw what happened between Daisy and Martin in those 8 minutes. We do know that a judge had previously granted Daisy a restraining order against Martin, that she had in the past called police for him breaking in her front door, and that neighbors had seen and heard him hurt her and throw a rock through her car window. The circumstances on the night of the stabbing reflected chaos rather than calculated and cold-blooded murder. Before arriving home that night, Daisy had been knocked unconscious when her car spun off the road after Martin grabbed the wheel. The Uber driver described both Daisy and Martin as crazy when he saw them swearing and kicking each other in the back seat. Later, when police arrived at Daisy's home, she behaved erratically and angrily, even though she was the one who had called them. The state attempted to overcome the facts from that night by leaning on the improperly admitted testimony of Martin's mother, who was allowed to tell the jury Martin's self-serving version of an alleged fight with Daisy a year earlier. The state relied on this highly prejudicial story during its closing argument, treating Martin's account as the truth. The jury was then instructed it could consider this evidence to establish the intent necessary for first-degree murder. The trial court's errors in admitting the evidence denied Daisy Martinez a fair trial. The primary error in allowing the testimony was that it was contrary to the hearsay rules, and I think we need to discuss this first because if it is inadmissible, it's hearsay.
Let me make sure I understand, because there seem to be sort of, well, two separate types of evidence that you challenged. Number one, the actual statements to Miss Grady, or her testimony regarding those statements. And then separately, you appear to challenge photographs that were admitted showing prior injuries, allegedly.
Yes.
And so which buckets do, first of all, I guess the first question is, which buckets do each of those fall in? The hearsay, was the objection hearsay-based, or was it Rule 404B based?
Yeah, that's great. Let me try to clarify it as best I can. I think hearsay basically applies to everything here because those photographs were admitted as illustrative testimony, as illustrative evidence of her testimony of that fight. And otherwise, they don't really have a basis to come in. The challenge to the evidence was both under the hearsay rules in 803 and under 404B. I think just intellectually we should deal with hearsay first, because if this evidence was hearsay, it can't come in for the substance, and if it can't come in for the substance, it should not. That resolves the 404B issue. But there is also a 404B issue which I would reach as the alternative.
Which kind of brings me to my next question, which is sort of the issue surrounding preservation of those objections.
Yes.
Obviously, there was a sort of a voir dire, a 404B conversation with the trial court prior to the introduction of that evidence. But I think what we'll hear from your colleague on the other side is that the objections were either ambiguous or perhaps only limited to hearsay when the evidence was actually introduced at trial. Would you address those preservation?
Sure, I can address those. The issues raised in this appeal are preserved, and if our preservation rules are meaningful, then certainly this issue is preserved because it's the issue that was raised repeatedly before the trial court, both in that voir dire hearing that you mentioned and in the objection. Now, there were at least 12 objections, I believe, during Ms. Grady's testimony. The first one that came to her when she started giving the beginning of the statements that Martin made was the hearsay objection, which got a hearsay ruling from the trial court at that point. Several of the other objections, the ground either wasn't stated, but there was a reference to prior grounds, both the photographs and the testimony. The prior grounds would be that voir dire hearing, which at length the parties went through hearsay and 404B. It was called a 404B hearing. The court's ultimate ruling was on Rule 404B, but hearsay was actually the first issue they needed to address. The state brought that up at the very beginning, that this was hearsay testimony and we need to resolve this. So, I believe that this is quite clearly preserved. There's no question that the trial court understood these to be the issues, gave rulings on the issues, and perceived that the counsel was objecting to them both in the voir dire and during the testimony. And that allows them to be raised on.
My question's about the photographs.
Yes.
They were identified. I know you have an argument is on the validity or the substantiability of that identification, but were they not just admitted for illustrative testimony only? Is that correct?
That is correct. They were admitted.
And did the trial judge also give the jury a limiting instruction as well?
As to, yes, in the final instructions, there was an instruction on illustrative evidence.
So generally, if they're not asserted for the truth of the matter, basically hearsay would have to be something that's admitted for the truth of the matter asserted. Do you agree with that?
Yes.
And if the photographs are admitted to illustrate a witness's testimony only, and the jury is instructed on that, would that not remove any hearsay objection as it relates to the photographs?
No, not in this case, because the testimony that it was illustrating was her testimony of what.
That's a separate issue.
Martin. Yeah.
Whether or not they were substantially validated, that's one argument you have.
Right.
But presuming they were, and the standard's a very low bar for that, once the trial court limited their admission and so instructed the jury, would that not cure any hearsay objection to the photographs?
Well, I don't believe it would, and I think that there's a little bit of a theoretical problem, right? Because to conceive of the photographs as being separately admitted, they then become disconnected from any issue or testimony in the case. I mean, the entire import of these photographs is that they supposedly show injuries that Daisy gave to Martin in the way that Ms. Grady described.
So you're objecting to everything the mother testified to, is that
Yes.
correct? Including any exhibits that were used during
Yes,
that testimony?
I think the exhibits are entirely derivative from her testimony, and otherwise they have no connection to the case.
Thank you.
So I'll begin, and I'm happy to answer any questions that come along the way. I'd like to begin with the state of mind exception to the hearsay rule. When the state, again, in that voir dire hearing, the state first admitted this was hearsay evidence and was offering it for the truth, because they were offering it for ultimately a 404B purpose. And the state's first argument, also the trial court's first ruling, was that it was going to be admissible as for Martin's state of mind. And I would just point to volume 5, page 975, is the state raising that at the beginning. And volume 7, page 1339, is where the trial court gave that ruling, and that was the trial court's primary basis.
What's your page number on volume 5?
975.
Thank you.
The idea of the state of mind exception is that a person's statement of how they feel right now is generally trustworthy evidence of their actual state of mind. The rule itself specifically exempts facts remembered and believed so as not to eviscerate the hearsay rules. Now, the state of mind exception has many applications. In a criminal case, it often comes in related to the victim's fear of the defendant. And in that situation, facts are sometimes admissible and necessary, not just to contextualize, but also to avoid some prejudice and misuse from naked statements of fear. Was what the Supreme Court said in the Meekins case. I think the authority cited in the briefs that's most relevant to the state of mind exception is the case of State versus Hardy, which is, the site for that is 339 NC 207. It's a 1994 North Carolina Supreme Court case in which the court said that it was clarifying Rule 8033. And several aspects of Hardy are relevant here and worth discussing because there are some similarities in the facts, but also some very important differences that show why the error that occurred in Hardy occurred here. But in this case, there actually is a need for a remedy. Hardy was a case of a husband who murdered his wife while they were separated. They still owned a restaurant together. He arrived early in the morning when they were alone and stabbed her multiple times, then left and made it seem that it was a robbery. The similarity is just this is two people alone and there's a stabbing, and he made some contentions about what had happened between the two of them. The evidence that was in question was that a few days before this, several witnesses had seen a violent outburst at the restaurant. There were employees there who had seen him throwing things and hitting her, and there was actually more than one incident, but there was a particular one. And in addition to the witnesses, she had described this incident in her diary. She had written down a description of what happened and then her intention to get a restraining order. And the question was, and it included a few more facts than were in the witness testimony. The state tried to get it admitted, the trial court admitted it. The Supreme Court held it was error, that this was a description of an event. She did not in the diary talk about how she felt about it, what her state of mind was. Even though one could imagine or infer what her state of mind might be, that's not enough to admit a factual statement, because that would allow anything. There needed to be some expression of a mental state, and there was none. And so the North Carolina Supreme Court held that the evidence was inadmissible hearsay. Also relevant to this, which comes back to this interplay between Rule 803 and 404B. In Hardy, the trial court had also given the jurors a 404B instruction, because that's how that evidence was being used. The North Carolina Supreme Court said that was error, because that's telling them they can use it for the truth of the matter asserted. So those were connected errors in that case as well, because that's the purpose of the evidence, so certainly for truth. Now, one of the differences in Hardy, though, is there was no prejudice. So even though these errors were found, there was no relief. And the reason is because the state called the witnesses who had seen the same event. The thing that the state didn't do in this case, or didn't attempt to do, was find this friend who was supposedly present for this, the fight that may or may not have happened.
Let me ask you this. If we would agree with you that the mother's testimony and all the exhibits was error,
Yes.
in light of the other testimony from the Uber driver, from the EMTs, from the officers, from the bloody knife to the video, everything else, when you take all that, even if it was error in the mother's and the exhibit's admission, how can your client show prejudice in light of the other overwhelming evidence of guilt and her conduct, the knife, etc.?
Yes, thank you for that question, because I want to clarify exactly what I'm arguing here in terms of prejudice. I have not advanced in this brief an argument to this court that there's a reasonable possibility the jury would have concluded she didn't do this. The only argument before this court is as to the difference between second and first degree murder. That's where the prejudice is. And that's where the prejudice is in some of the cases that have been cited here, such as Hardy. It's really about this question of premeditation and deliberation. That evidence that you cited is evidence of guilt, but the evidence of premeditation and deliberation was incredibly thin.
Let me ask you this. If the Uber driver testified to the argument between the two of them in the car and what happened there, And then the third party, I can't recall his name, but the third party that was with them that night,
Joel.
he testified. Um, you had them as the only two persons at the scene, correct?
That is correct.
And you had a victim outside bleeding with a murder weapon that was inside.
That is correct.
And your client also alleged that the victim had committed suicide.
Well, that was the defense advance during the trial, yes.
Where the medical examiner said that the wounds, it would almost be impossible for someone to use a knife to commit suicide that way.
Yes.
You look at all that evidence, and then when we look at premeditation, and then you look at the prior history between the two, aside from the mother. I want to understand why there wasn't sufficient evidence of premeditation deliberation if you take everything else and disregard all the mother's testimony and her exhibits.
Okay. Well, then I think I might refer to a different case that I think would be helpful for this. Case of State versus Williams, 144 NCF 526, 2001. That's a case where the evidence was found insufficient for premeditation and deliberation. I don't know if it was 25 years ago, Judge Tyson, but you wrote a dissent in that case that would have found evidence of premeditation and deliberation. And I think this case can be distinguished based on the analysis, both for the majority and the dissent analysis as to how you would have found it in that case. Williams was a case involving a fight that people saw. It was between two people who didn't know each other outside of a bar. Okay? And there was testimony that the victim had come up and the defendant had at least initiated something with the victim, and then there was something else that they did back, and then the defendant pulled out a gun and shot him 3 times. And after the shooting him 3 times, leaving him on the ground, the defendant got in a car and left, and then was not found at his house, was found several days later. Now, in that case, based on a number of things in the interaction, this court found there was not evidence of premeditation and deliberation in that whole threat. Judge Tyson, in your dissent, you would have found it, and the basis on which you would have found it in that case had to do with both the evidence, because the interaction was seen, that he initiated that and escalated by pulling out a gun that he had, but also the evidence of what he did afterward, that he very intentionally left the scene after this person had been shot 3 times and was visibly dying. In this case, there's a few significant differences. We don't know exactly what happened in that room. We know they were kicking each other in the car. She supposedly hit him in the car. But we don't know what that interaction was like. In terms of what happened afterward, there was a lot of testimony about her erratic behavior and how she was fighting with the officers and wouldn't put on clothes and all these things. What we don't have is this evidence of flight. She called 911.
They both did.
They both did. And that's also important because when the officers arrived at the scene, in terms of what happened in Williams, where he shot this man 3 times, and he sees he's going to die and doesn't offer assistance and leaves. In this case, when the officers arrived at the scene and they found Martin Garcia out front, they couldn't tell what was wrong with him or that he was dying because he had this one fatal stab wound. And because he was bleeding internally, it wasn't obvious. And we also know from the call that he continued to walk and talk and move around for 10 minutes and got outside of the house and made his call to 911. It is not like someone who's been shot 3 times who is obviously dying on the ground. And it is not someone who ran away. Yes, she was in the house. There was all sorts of testimony. She was trying to get up, stand down. But at the same time, the knife was there on the counter. The blood was there. Nothing was cleaned up. There's no evidence of the kind of disengagement and trying to hide from what was happening. It is much more chaotic and more desperate in a way. I would say that...
I understand your client did not have any type of wounds or any other signs of a struggle either. Is that correct?
That is correct. That is correct.
So the only wounds were on the victim and the knife was there. And
yes, and this Self-defense was not raised at trial, and I can't argue that here. And as I've said, in everything that I've raised in this brief, both the evidentiary issue and the other one, I'm talking about prejudice, it's really that I can see that there was sufficient evidence for her to be convicted of second-degree murder.
Did the trial judge give an instruction on second degree?
Yes.
And the evidence for her 911 call came in,
Yes.
was played to the jury. So all the mitigation evidence that you are arguing today, that was all before the jury.
Yes, and I'm not arguing it as, I mean, we're not in a capital situation with it as mitigators in that way. But yes, the facts that I'm arguing today come from the record for the jury. Now, what happened in this case is the jury had these additional facts. Like we're talking about this testimony comes in about what happened a year earlier, and that was presented to the jury in violation of the hearsay rules and 404B. It's propensity evidence. I mean, the state got up and said, look what happened a year before, and now she's back a year later doing it again. You could use this for intent. And they received an instruction, a 404B instruction about that specific evidence that they could consider it in considering intent.
Let me ask you this. Your client had received a DVPO, domestic violence protection order. Is that correct?
That is my understanding.
And the mother of the victim testified that the reason that her son had asked her not to call the police about what happened a year earlier was because of that order?
Yes.
And the jury heard that too?
The jury heard a version of that. So, she testifies twice. In voir dire, it is more explicit that it is teased out that this was a restraining order. I forget the term she uses for the jury. It's something like they had restrictions and weren't supposed to see each other.
But didn't she also testify that her son did not want the police called due to that?
Yes, she testified.
That would have put him in violation of that order.
Yes.
And that would have been favorable to your client.
Had that happened?
No, that testimony from the mother that your client had sought a protection order and that at the earlier altercation the son had not wanted a police call because it would put him in violation of that order.
Yeah, what came in before the jury was that they had restrictions, they weren't supposed to see each other, and he was concerned. The fact that there was a restraining order issued by a judge was not really presented to the jury directly. But yes, I mean, that came out in her testimony in I think a little bit of an oblique way, but yes.
So why doesn't that fit, sort of circling all the way back to where you started your argument, why doesn't that then squarely fit it under a present sense impression exception to hearsay? If the testimony is he was concerned, and then other parts that he was afraid for the child.
State of mind.
State of mind.
Okay, so yes, so the state of mind exception to the hearsay rule is the state of mind has to be material to the case. The state of mind that is supposedly that the state has argued that this was admitted under is his fear of her. And that therefore all of these facts of why he was afraid, I mean, that's supposedly the basis for the details of this interaction. He's afraid of her because of this. Except that that wasn't his testimony. He didn't testify that he was afraid of her. And the facts of the interaction as he relays them actually give a number of reasons to question whether that was true or not. I mean, in voir dire we learned that, he had told his mother earlier he was going that night to see a male friend, not her. And this is while there was a restraining order. We do not know how in those several hours he ended up at the house where she was with her friends having this supposed argument. We don't know that. And we don't know her side of it. We don't know what injuries she may have had. We don't know anything else.
But the victim went to her house. He didn't go to hers. She didn't go to his, right?
She did not go to his. No, the testimony was that this was at her friend's house, and he had gone there. And then there was supposedly an argument about the child, and he said his concerns were about, he left when she was calling the police, so this goes to excited utterance too, this sort of delay in calling the police, he left because of that, and then goes through a series of phases before he gets to her house where he's picked up and he's given a ride home and all that. And he's not expressing a state of mind. And so when going back to Hardy and some of these other cases, also Lassane, The fact that someone describes an event that you think might be frightening to them doesn't mean they're expressing their state of mind and then the event comes in. It's got to be the other way. They have to be expressing the fear that's the supposed basis for the evidence.
Earlier, you mentioned the 6-minute lapse between when the Uber driver delivered them to her house and her first call. Is that correct?
Yes, I want to make a correction because I have the times right in the brief, but for some reason I said 6 minutes. It is 8 minutes between that exact moment of the Uber getting out of the
I think
call.
you're arguing that as, that's too brief of a time for someone to form premeditation deliberation.
Well, I'm not making that argument because we know that there is really
I just
no
want to
time,
clarify. I
no
want to
time
clarify
too brief. But it's important for that analysis that we look at how brief that time was and when it's understanding these facts and what does the evidence show.
And this was argued to the jury as well.
The amount of time, yes, the times were argued to the jury. Yes.
So again, I understand, you would have hoped at minimum for a second degree, but the jury heard the whole story, heard both sides.
Well, the jury heard the whole story, including this story about Martin's, again, very self-serving account of an attack by her a year earlier that the state emphasized in closing argument, that the jury was instructed on, etc. I made this alternative sufficiency argument, even including that evidence. But the first argument about the evidence itself is that this made a difference. This is prejudice, because this is not an obvious case of premeditation and deliberation without that evidence, and that evidence was relied on and it was important to the state's case.
And do you agree that there were certain parts of the mother's testimony that was beneficial for your client?
Yes, there are aspects of it I brought on the brief because I think it can be, there are facts you can draw from that might be favorable, yes. With that, I'd like to reserve the rest of my time, if I may.
Okay. You have about 9 minutes.
Oh, sorry, it says 4 minutes on the thing.
Yeah, 4 minutes.
Oh, okay, I'm sorry.
Okay, sorry.
Yes, thank you.
Thank you.
Okay. Hear from the state.
May it please the court, my name is Ben Zaney. I'm with the North Carolina Department of Justice and I represent the state in this matter. Evidence that about 1 year prior to Garcia's murder, the defendant attacked Garcia, leaving him with bite marks, cuts, and bruises, was admissible under Rule 404B. Garcia's statements describing this attack fall under several hearsay exceptions that have been discussed so far, but I especially want to note the excited utterance and the then existing statement of a then existing mental or physical condition. In addition, the trial court properly admitted this evidence under Rule 404B, and even assuming that any part of that admission was error, the defendant fails to show prejudice since there was other compelling evidence of the defendant's intent and malice towards Garcia, which were the 2 reasons that this evidence was admitted. Finally, turning to defendant's second issue briefly, there was more than sufficient evidence of first-degree murder, including premeditation, deliberation, and specific intent to kill, well, at the standard which is just a light most favorable to the state, taking all evidence, resolving any contradictions in favor of the state. In that standard, there was plenty of evidence to submit the charge of first-degree murder to the jury. Thus, the state will request that this court affirm the judgment of the trial court below. I want to begin with the hearsay exceptions, particularly those 2 that I mentioned. I do intend to rest largely on the brief with regard to the residual hearsay exception and the preservation points, but of course I'm happy to address any questions related to those. I want to start with the excited utterance exception to hearsay under Rule 8032. An excited utterance is a statement relating to a startling event or condition made while the declarant was under the stress of excitement caused by the event or condition. And it's apparent in the testimony given by Garcia's mother, both at the 404B hearing and in front of the jury, that these disclosures were made to her in the initial phone call he makes to her right after this event occurred. She describes, when she's asked, do you recall what he was saying in the initial phone call? She just said, well, he was crying, so he just told me she was really drunk and had hit him, and he was afraid for the baby. And just to address some of Your Honor's questions to my friend on the other side, that statement says, so he just told me that she was really drunk, and implies just told me she had hit him, and just told me he was afraid for the baby. All of those things would fall under the present sense impression of things that he was feeling in that moment, but also would fall under excited utterance. Additionally, when she testified in front of the jury, she testified when she was asked, do you remember what it was like when he called you on the phone? She testified, when he called me, he was crying, and over everything else, he was scared, and then he told me she had beaten him. So again, under both of those circumstances, it's clear that we have a startling event. This court and our Supreme Court have both held that an assault is a sufficiently startling event, and we have these disclosures about the defendant being the one doing the assaulting right in the initial part of the phone call between the victim and his mother. And so this isn't a situation where there's a long period of time. In fact, we know that from two particular pieces of evidence in her testimony. She testifies that she picked him up at a gas station nearby where it happened, meaning he couldn't have gotten far from where it happened. She also testified that the bite marks were still wet when she saw them. And again, that also indicates that this was a very quick, and she's seeing the bite marks at the time she's picking him up, not at the time he's making the phone call. So again, the phone call itself is quite prompt in time according to the record. Additionally, to the extent that Garcia's later statements to his mother are important, she testified that when she picked him up, he was still crying, he was still scared. And this court focuses on the mental state from the perspective of the declarant. And so based on his mother's testimony, when he was giving those statements to her at the time of pickup even, he was still crying and still upset. She said he was crying hard and was upset. So again, we have this sort of ongoing reaction to this assault, which this court has held in cases like State versus Coria, is applicable, still allows admission of the excited utterance exception, even when there's not a specifically delineated time frame of minutes or seconds being described by the evidence.
You familiar with the expression, gild the lily?
No, Your Honor, I'm not.
The lily is a very beautiful flower. So if you've got a beautiful thing, why do you want to gild it, add to it? What was the purpose of the mother's testimony? This evidence here was very straightforward. Why did the state want to gild the lily?
I understand, Your Honor, the concern that essentially why push the envelope, I guess is what I was, the phrase that I would be familiar with, Your Honor. But to the extent, I believe that the evidence is admissible, Your Honor, and the state can offer admissible evidence. I can understand the concern about not wanting to get too close to a line, Your Honor, and I didn't try this case for the state below. I'm certainly not casting aspersions on those who did, but I do think that this evidence is admissible. I don't think that it was error for the prosecutors to attempt to offer this evidence or for the court to admit it. And I can understand certainly wanting to show the jury as much of the full picture as one can. So I do think that there are reasons for the state to offer this evidence, even though, as has been discussed, or as I'll discuss later, the prejudice here, any prejudice from this being admitted, even if it's admitted in error, defendant fails to show prejudice, essentially.
But isn't that exactly what Rule 404B is concerned with? Even though it's a rule of inclusivity and not exclusivity, but isn't the one thing it's concerned about is the state or the party offering it relying on that evidence to say, well, look, if she acted this way then, she must have done the same thing again here, that she acted, so what is it probative of other than that?
Well, I think it's fair to say that that's the concern of 404B, but this court and our Supreme Court have held that if it's being admitted for any other proper purpose, which
it's the rule of inclusivity,
intent and malice here, which is what the trial court admitted it for, then it is proper to admit it. And it's not a focus on propensity, it's a focus on the malice that she had towards this particular person and her intent towards this particular person, who's the person who's ultimately found dead outside of her home with the bloody murder weapon found inside her locked home with her. And so under these circumstances, I don't think that it was a propensity argument. The court gave a limiting instruction specifically right after the direct examination of the witness in front of the jury, and then also gave a second limiting instruction in the general jury instructions at the jury charge.
Does the state assert that the trial judge did an adequate 403 prejudice analysis on this testimony as well?
Absolutely, Your Honor. The court heard the testimony first outside the presence of the jury, analyzed 404B, but also specifically talked about 403. And in addition to that, just one moment, Your Honor, I can find it in my notes. I know I have more to say on that. The court provided the 2 limiting instructions to keep it narrow. And additionally, the trial court also struck other evidence that the state was trying to offer under Rule 404B. So it's clear that the court was considering evidence, striking evidence that it actually thought was violative of 403 or 404B.
The defendant's trial counsel had made multiple motions to in limine and motions to suppress and motions to exclude. So obviously there was a concern here at the very beginning that this evidence would be brought in either to purely to show propensity or to excite the jury on behalf of the defendant. So the record's clear on that. They were trying to get rulings from the court before this evidence ever came in.
I understand, Your Honor, and to the extent that this is about the preservation argument that the state raised, I think that the preservation argument that the state raised is stronger with regard to 404B than the hearsay. I think that that's fair to say, just because I think our rules and our case law are clear that it's not just enough to object outside the presence of the jury. The party has to object in front of the jury. And here the initial objections from the defense counsel were about relevance and personal knowledge, and then eventually added hearsay. And her objections, or the defense counsel's objections, were coming at times where the witness was saying things like he said or he told me. So in context, all of those could be considered hearsay objections, but she didn't say on prior grounds, at least not by my reading of the transcript, until the photographs were offered.
Is it proper for the state to offer illustrative testimony or illustrative evidence that's not admitted for the truth of the matter asserted, but to illustrate as a way to avoid the hearsay rule? Is that a legitimate use of illustrative evidence?
Your Honor, I can't say one way or the other on that.
What do you think?
My instinct would be no, Your Honor, but again, I don't have a case in front of me either way on that. My understanding is it's proper to offer illustrative evidence generally to the jury. I don't know that the record...
If you have the proper foundation and
yes,
you show it's germane, et cetera, et cetera.
Right. But I don't know that this record, to the extent that that question pertains to this record, Your Honor, I don't know that this record shows that there was any intent by the prosecutors here to use it in that way.
Well, if that being the case, what exactly were these photos illustrative of, germane to this case?
Well, they're illustrative of the actual injuries that the witness herself saw the victim have. So the witness herself saw that the victim had these wet bite marks, was bleeding, and these photographs were illustrative of what she was describing to the jury, and they helped her explain or show the jury what she was saying. And that's particularly through the context of this witness was testifying through an interpreter. So it might have been an additional reason for the state to want her testimony illustrated just in case the testimony through an interpreter was not fully clear.
But a lot of times we see these illustrative exhibits kind of sort of generated, right? They're not substantive photographs. They might be, you know, a picture of an outline of a body and show, oh, can you show me where you saw that bite mark? Oh, well, it would have been over here. Here we actually have, they're substantive photographs of the actual injuries. And I think that's perhaps kind of where Judge Tyson is getting to. This isn't just your typical illustrative exhibit. It's really almost bolstering her testimony and kind of corroborating her testimony where she says, yeah, I saw bite marks on my son. Oh, well, here's the photo, right? So I guess I'm trying to figure out where you draw that line between an illustrative exhibit and what was actually sort of essentially substantive corroborating or bolstering of the witness's testimony.
I understand, Your Honor. I guess the state's position here would just be that, and I don't think that this is really discussed in the briefs by either side, but I think that here, again, I think maybe perhaps because of the interpretation, the witness being testifying through interpretation, meaning the questions have to be interpreted to the witness and then the witness's answers have to be interpreted back. Maybe that was the concern. This is a unique circumstance that's not present in other cases where you might have photographs offered as substantive evidence. But overall, I don't think that it was improper to offer these photographs as illustrative of this witness's testimony. in the same way that perhaps a photograph of the crime scene could be illustrative to help a law enforcement officer describe what they saw on that particular day, or even a diagram. I think it falls within that same class of trying to help illustrate for the jury this witness's testimony rather than being a standalone exhibit. So I will turn to the prejudice analysis then at this point. So here it seems that defendants are really focusing on the prejudice with regard to premeditation, deliberation, and intent to kill. And here there is, the state's position is that there's overwhelming evidence, or at least compelling evidence, of intent and malice, which were the two reasons that this evidence was offered. I think perhaps the most important piece of evidence this defendant has alluded to, it seemed that the parties below agreed that both sides argued to the jury that the stabbing had occurred before the defendant's 911 call. At least that's the argument before the jury. The defendant is calm on the 911 call. The few seconds that we have of that 911 call, she's relatively calm. She's not screaming at the 911 operator. There's nothing erratic about her statements to the 911 operator. In addition, when law enforcement show up in response to her call, the door is locked and she is apparently asleep. Now, whether the jury or whichever you believe, whether you believe that she was actually asleep, then that means that she had calmed down enough to fall asleep after stabbing somebody, or alternatively, if you believe that she had the presence of mind to pretend to be asleep. In either event, that shows that that's a deliberate action taken just moments. The law enforcement was there at 3:40 a.m. And her 911 call was approximately 3:32 a.m. So within minutes, we have another deliberative action, I believe. And then going back to the Uber driver's testimony, she gets into the Uber. She tells Joel that he's not to be in the Uber. She directs the Uber driver to go to the McDonald's to pick up the victim. All of these are actions that shows that she's in control of her faculties. She's not acting at the whims of her emotions. And then additionally, there's the punch in the back seat, which is not reciprocated by the victim in this case. Again, tending to show malice and a specific intent to cause him harm that night, minutes before he is found stabbed by law enforcement.
If I remember correctly, the officers arrived at the scene within 3 minutes of the decedent's phone call. Is that correct?
That's correct.
You said within 8 minutes of hers, but I think within 3 minutes of his.
Yes, Your Honor, and as I recall, the testimony was that they were responding to her phone call initially, and that might be why they're so quick in response to his. Yes, Your Honor. But they were there at 3:40 a.m. and his phone call was at 3:37 a.m. Your Honor. And then in addition,
Now, what do you think about? If I remember, there were like 17 calls from him to her, and 9 calls back to him. This was in the interim between the wreck and the Uber. Is that correct too?
Yes, Your Honor. Sometime between the evidence tended to show that there was this accident on the interstate, that they each fled the scene of that accident, and that the victim separates from the other two, from the defendant and Joel, and that at some point the phone records show that there's phone calls back and forth, like you indicated, Your Honor, a number of phone calls back and forth between those parties.
It was a third party that called for the Uber.
It appears that way in the record. There is some dispute about that, but it does appear in the record that it is that way. The Uber driver says that he thought the defendant was the person, but the Uber records themselves show that Joel was the one who called for
The third party.
Yes, Your Honor. Yes, Your Honor.
So I guess, it looks like, when you're talking about 17 calls one way and 9 calls the other, it wasn't. That was striking to me, I guess, within that very short window of time.
Well, Your Honor, I believe it's 17 calls total. With
17 total?
Yes, Your Honor. So 9 being from one to the other, and if my math is correct, 8 being the other way. And I can't in front of you tell you how long each of those phone calls was. I think that's more apparent in the transcript, Your Honor. But as I understand it, there was a question about whether those phone calls were connecting potentially, or if the phone calls lasted mere seconds.
The defendant obviously knew where he was because she directed the Uber driver to drive to the McDonald's to get him.
Yes, Your Honor. Yes, Your Honor. That appears to have come through one of those phone calls based on just putting the pieces together.
Does the state think that's some evidence of premeditation, that she picked him up to kill him?
I think that a juror could reasonably infer that, Your Honor, which is all that is required for an instruction on first-degree murder, is if a juror could infer premeditation and deliberation. And so perhaps yes, she did pick him up with an intent to want to make sure that she was in the same place as him. She punched him in the back of the Uber in apparent full view of the Uber driver who testified about it.
And that was also a reason for her to exclude the third person too?
Right, Your Honor. I would say believe so. So all of those things are things that a reasonable juror could infer, which is certainly permissible in terms of, that's the standard that the trial court would use to determine whether to give an instruction on first-degree murder, whether to give an instruction on premeditation and deliberation. All of that evidence, we believe, does support the instruction on first-degree murder, Your Honor. The only other thing that I wish to add to the premeditation and deliberation discussion is that the medical examiner's testimony, that these were stabs, these were not slices. The medical examiner testified, I believe, about typically with knives, if one is to commit suicide, which is what her allegation was, the defendant's allegation was, it's usually slashing type thing, whereas this were stabbing wounds. One of the stabbing wounds was clear through his arm and a little bit into his side, which again the medical examiner testified was not typical. And one of the factors that this court and our Supreme Court consider with regard to whether the evidence shows premeditation and deliberation is the brutality of the injuries. Here are these deep stabbing wounds, including the one through the arm, the state believes would tend to show premeditation and deliberation and at least allow a juror to make that inference just based on the nature of the injuries.
In fact, there were multiple stabs
yes,
as
Your
opposed to one.
Yes, Your Honor.
That's evidence of premeditation?
I believe so, Your Honor, yes. I mean, multiple injuries would indicate that more than one attempt, and even if there's a moment to consider between those stabs, that's an opportunity to premeditate and or deliberate, Your Honor.
I understand the testimony from the officers who arrived on the scene within 3 minutes of the defendant's call is the victim was up walking around, and it wasn't even apparent to the officers that he was gravely wounded, correct?
That is correct, Your Honor.
The jury heard that?
Yes, with one clarification, I believe that they testified that they found him because they heard him moaning and groaning. So I'm not sure that he was walking around, Your Honor. I believe that he may have been laying in the yard at that point. But it was correct that the officers at the scene testified that it wasn't immediately apparent to them how serious the injury was. And I believe that either the medical examiner or the EMT testified that it was because there was a lot of internal bleeding, not as much external bleeding. Yes, Your Honor.
So does the state argue that even if we found the mother's testimony was unlawful and prejudicial, that we would still sustain the judgment and the verdict based upon other evidence?
Yes, Your Honor, absolutely. Based upon, yes, Your Honor. To leave it simply, yes, Your Honor. With regard to the factors for sufficiency of the evidence for premeditation and deliberation, just one of those factors is ill will or difficulty between the parties. So that 404B evidence would really only fit within that one framework of considering premeditation and deliberation. And there was a lot of other testimony at trial, some elicited by the defense themselves, talking about the multiple prior domestic situations here that the jury would have heard about the long-standing difficulties that these parties had, even without the 404B evidence. And in addition to the Uber driver's testimony about the fight that was happening moments before this murder. And even the defendant told police in one of the versions of her accounts, she told police that they had been fighting and that they had separated that night and gone back to the house separately. That was one of her versions of accounts. But even under that version of account, a juror could infer that they had been fighting that night, even if they were to disregard other testimony. So based on all of these circumstances, unless the court has any other questions about any of the issues raised, the state would respectfully request that the court affirm the judgment below.
Okay.
Thank you.
Thank you. Rebuttal? I think he left you exactly 4 minutes, so I guess
Thank you. Either way. So in terms of the Judge Tyson, what you raised about gilding the lily, I won't concede that there was a lily, but in terms of the state wanting this for the impermissible purpose, I just want to point out that
Do you think prior conduct between the parties, particularly violent conduct, has some that would be a permissible purpose, ill will or malice between the parties?
It may be. I mean, not for the state of mind exception to the hearsay rule. I mean, if you look at the cases that are cited on this, these domestic violence cases, what we have is its connection, either it's very close in time, or it's connected with explicit death threats. The Wilds case with the pouring gasoline on the nightgown, the other one where it's sneaking into the apartment in the prior month. This is totally different, disconnected. And the thing is that Ms. Grady couldn't offer real testimony about the relationship. And the reason was she said she didn't know Daisy Martinez. She refused to get to know her. We know she hated her. We don't know what the reasons were. But from the very beginning she did, never allowed her in her house, only spoke to her one time on the phone, never saw the two of them together. This was not a witness, as there are in some of those other cases, about the course of some long and troubled marital relationship. The sole purpose for her was the purpose that the state brought her in for, was to give this testimony about Martin's version of events so they could use that to argue intent to the jury.
Let me ask you this. I think the testimony was that the third person, I forget his name, but the third party I've been referring to that lived.
Joel Fonseca.
Yes. My memory was that he had bought a car for your client.
Correct.
And your client was driving without a license.
Correct.
And that the victim had, or the deceased had grabbed the wheel and caused the car to wreck.
That was his testimony.
And the car was 2 weeks old. They'd been here in Raleigh partying and drinking.
Yes.
Was there any type of diminished responsibility or intoxication evidence that was offered at trial?
No, there was no expert put on to discuss those things. There may have been some mention of it. There was certainly mention in closing argument. There was some mention of the car accident.
Mentioned by the defendant during her closing?
I'm not certain. They did not put on an affirmative witness.
And there was no claim of self-defense?
And that was, question as to whether that was raised came up a few times, and the defense counsel was very explicit that they were not raising it in the case. In terms of excited utterance and the 2 phone calls, I just want to respond to a point the state made and just refer to a piece of the transcript, volume 7, pages 1339 to 40. That's Ms. Grady's testimony before the jury about that phone call. It differs from her voir dire testimony. She does not make all of those statements about his expressed emotions, which I still would contend are not material. They're not about fear of Ms. Martinez. She makes a much more terse statement that he said she beat him and he was scared in the version before the jury. The state did try other 404B evidence that they didn't get in addition to this, and for the same reason they were putting this in, they needed it. They needed something to push this case past the sort of chaotic facts, the very brief period of time, the known history of mutual violence between the parties, and we have no witnesses to the event, and what happened afterward, it doesn't have the kind of things that this court has found to show clear premeditation and deliberation. And I think that a lot of the cases cited, those domestic violence cases, provide very clear contrasts because there is such explicit evidence there of the intent, the prior threats, etc. So I would ask this court, for the reasons stated in the brief, to order a new trial for the inflammatory and inappropriate evidence that was admitted in violation of hearsay of 404B, or in the alternative, to remand for entry of judgment on the lesser included secondary.
Thank you.
Thank you.
Thank you for good arguments. You have any other questions? We'd also like to recognize the presence at the bar of Mr. Glenn Girding, our appellate defender, and we thank you for your presence here today, too. The case is submitted. We thank you for good arguments. There being nothing else on the docket, Mr. Saunders, will you adjourn court?